see we can put. The numbers are starting to increase. Excellent. So we'll just wait for a bit until everybody's equal. Wish that was building quickly. That's great. Kia ora koutou. We're just waiting for the numbers to increase. Well, they're starting to stabilise now, so I think we might make a start. Right, so kia ora koutou everyone, and no mai haere mai ki te wiki o privacy. It's my real pleasure to see you here today. Ko Liz MacPherson, aho, that's Liz MacPherson, and I am the Deputy Privacy Commissioner. So welcome, and welcome to Claire Achmad, who is the CEO of the Social Services Providers Association Te Paiora. Welcome. Thanks, Liz.
Kia ora koutou.
So welcome to Privacy Week, and this special session, which is focused on social services providers and privacy, and a real focus on personal information as a taonga. We know as the Office of the Privacy Commissioner that there's so many agencies out there who are holding personal information, and all of those agencies are covered by the Privacy Act. But all organisations are different, and social services providers are holding some of the most sensitive information and dealing with some of the most vulnerable of our citizens at very vulnerable times in their lives. So we wanted to have a particular focus on you today to cover off some of the issues for you as holders of the sensitive information. And I'm really delighted that I've got Claire with me today off the back of the Whakamanawa conference last week. And we have the opportunity to just chat about the issues that are confronting social services providers and how to take care of that personal information. So, Claire, what are some of the issues that confront social services providers and some of the challenges in looking after personal information?
Well, kia ora anō, Liz, and thanks for creating this space this afternoon so that all our social service providers around the motu can get hooked into this kaupapa, which is a really important one, and is part of Privacy Week, so really happy to be here and looking forward to hearing everyone's partai as well. But the point that you make regarding challenges, I think it's really important that we start there, because you're right. I think when we're dealing with privacy and with personal information, there are always going to be challenges, but certainly in our mahi and the social services and social sector, the reality is, because we are working alongside people all the time and constantly dealing with their personal information, that I think the challenges often are increased and are magnified. And as you touched on this, we're often working with people in really difficult and tough times in their lives. And so often the process of building trust is potentially a difficult one, and needing to hold people in relationships is really, really important. So when it comes to dealing with their personal information, we have to be taking extra care, I think, to be doing that well. So I think a first challenge that comes to mind is that, we need to just remind ourselves in social services work that I like to think of it as personal information as an extension of a person themselves, or it's actually part of them,
Absolutely.
And so, we treat people as taonga with respect when we work with them in social services. And the first challenge is just remembering constantly that when we're dealing with their personal information, we need to be treating that as taonga too, because it is part of them, it's an extension of them. So I think sometimes we can lose sight of that. So that's why I think, you know, having conversations like this in Privacy Week is really helpful. Also, when we're dealing with someone's personal information, that is their story. That is the story of their life. And especially because of the nature of the context that we're working with them in, often we are going to be recording or collecting and handling and perhaps sharing information that's extremely sensitive, but it is a part of that person's life, a part of their identity and a part of their narrative. So we have to take extra care with it. Then I think in terms of some of the other challenges, certainly, and I'm sure this will come up a bit more in our conversation today, often in social services work, because a lot of our kaimahi out there will be working in the child protection space, the oranga tamariki system. We have to be thinking about the challenges of how to navigate the sharing of information safely, but also to keep children safe as well. So that can often be quite a challenge, and sometimes the challenge of navigating as well when to share information, which information to share, and how to share that and who with. That can be quite challenging in our work, but it's something that is a day-to-day reality for the work that we have to do. And then I think a few other challenges that I think of when I kind of cast my mind back to my work in social services over the years and thinking about, you know, our member organisations around the motu too, accessing information. So often we will have whānau members, people who we work with in our work, who will approach our organisations wanting to access their personal information. So we need to be able to navigate how to do that in compliance with the legislation and policy that governs how that can be done well. From time to time, we will have a privacy breach as well, and so we need to be able to navigate that kind of challenge too. And then the last challenge that I think of, Liz, is just really around, I guess, keeping up to date with you know, changes and developments in this space of privacy and personal information. We live in the information age, and things are changing all the time. So just maintaining that awareness of what's going on in the privacy space is really quite a challenge when already kaimahi are so busy with the mahi that they're doing directly with families and whānau. It can be a challenge just to keep up to date with what's going on in this space too.
I agree. Well, those are just some fantastic initial points and some great pato there. But before we get on to your pato, I just wanted to talk to our audience out there and just say, look, in the Q&As, if you have any questions that you would like to put to Claire or I during the course of the session this afternoon, please use the Q&A function, not the chat function. We will look at those questions after about 30 minutes. And if there's anything that is actually pertinent to the conversation we're having at the time, we'll pick up on it too. But please feel free to add your questions in there and we'll look to answer them. But first of all, I think one of the things you talked about, Claire, was the importance of treating the information itself like you're treating the person. And from a privacy commissioner's perspective, couldn't agree more. And it's the message that we provide to all organisations that you should be giving the personal information the same respect you would the person sitting right in front of you, and treat it that way. And then I think a number of things flow logically from that. So we often get questions about the care of and the sharing of information around children, particularly when there's a belief that a child's at risk. And it always surprises me when I hear people say the Privacy Act stood in the way of me sharing this information. The fact of the matter is the Privacy Act will never ever stop you sharing information to protect the life of a vulnerable child. And I know that your experience with the Oranga Tamariki Act also says the same thing. So I think it's a really important message to get across, which is if you're confronted with a situation where the life of a child is at risk, or they could be harmed, or anyone could be harmed, the Privacy Act will never stop you sharing information.
I agree, Liz, that is such an important point to make, and I think a really important one to empower social services kaimahi in their work. And actually a few years back, there were some quite significant changes to the Oranga Tamariki Act, so the Oranga Tamariki Act 1989, some changes in 2019 that have since come into effect. And we've done quite a bit of work with our members at social service providers, Te Paeora or Aotearoa, to ensure that they're aware of these changes, because whilst the Privacy Act absolutely, of course, does apply to all organisations, including those working in the social sector and in social services, we now have some quite specific legislative provisions around privacy and child safety under the Oranga Tamariki Act that do apply and actually provide a clear framework, I think, for kaimahi and their work when it comes to child safety. So first of all, I guess important to touch on, the Oranga Tamariki Act, it applies to child welfare and the child protection system. And when it comes to the sharing of information and dealing with personal information, the emphasis is on ensuring and maintaining the well-being and the safety of children in tamariki. Obviously, wherever possible within the context of their whānau, hapu and iwi, but it makes very clear that information can be shared where that would assist to keep a child safe, basically, because the first and paramount principle there is that the safety and the well-being of a child or tamariki or tamaiti comes first. And so that the Act is really clear about that kaimahi are able to share that information. There is a requirement, however, of course, as you would expect, and as kaimahi out there I'm sure would understand, that sharing is done in good faith. And essentially what that means is that if you honestly and with good intent and on a good sound basis believe that sharing that information is going to assist in keeping the child safe, then you're probably going to be safe from any sort of civil or criminal charges or could come against you, because the underlying purpose behind that Act is that we do everything that we can to keep children in tamariki safe. Now, obviously, there's some nuance that needs to be navigated within that, because I think we talked earlier about relationships are so central to work in the social services space, and the building of trust is often something that happens over time, and then so sometimes when kaimahi are faced with this decision around, okay, looks like I'm going to need to share this information about a particular whānau member or family member. What's that going to do to the trust and the relationship that we've built over time with this family or whānau? Obviously, that is something to take into consideration and how you might navigate that. So we do need to operate on a principle that where possible, you let someone know if you're going to share their personal information. But what this legislation acknowledges as well is that sometimes there will be instances where, because of the need to keep a child safe, action and decisions need to be taken where that information will need to be shared, maybe without some of that transparency that we would usually want.
But I think, that brings me to an issue with respect to the collection of the information in the first place and the need for transparency when you're doing that. Because if you set things up right at the beginning, then when you come to the point of sharing information, then it's more likely that, particularly under the Privacy Act, you'll be able to do so because fundamentally it's all about purpose under the Privacy Act. So when you are collecting the information and setting up that relationship with the client, the person that you're trying to assist in the first place, actually being able to explain to them why you're collecting that information, how it'll be used to help them, and who you might need to share it with in order to help get those great outcomes for them. It's going to be really important. And if you've done that up front, so much of the other aspects of this are, I'm not going to say straightforward, because in this space there are always the relationships, but it does set you up well for the sharing of that information. So we would always encourage anyone, but particularly in this space, to have that initial conversation and make sure that you are that whatever documents you have, make it very clear why it is you're collecting information, the fact that you're collecting it in order to assist the person sitting in front of you, how you're going to use it, who you're going to share it with, and also things like how long are you going to keep the information, and how that person could access that information if they need to.
And that's so important as well, that process of helping people to understand the why and the what and the how, because that also gives people confidence, hopefully, as well, in your services that you're providing too. So, but you're absolutely right. I agree, Liz, that if it does come to a situation where for some reason that information is going to need to be shared, then having set things up well in that initial interaction and that building of a relationship, it's protective, I think, for both the people that we're working with and also for ourselves as kaimahi too. And I think as well it can be really empowering for people to have that good understanding of, okay, so why are you gathering my personal information? How are you actually going to record it? Where are you going to store it? How can I access it if I want to know what you've written about me, or if I want to correct that information? And I think as well, my work is predominantly focused on children and tamariki in my career to date, and for children and young people as well, they have a specific right to privacy under the UN Convention on the Rights of the Child, and I think wherever possible, when we're working directly with children and rangatahi, and in instances in social services work, we're often going to have to share some of their personal information that we've gathered, perhaps to link them up with another service or provide wraparound support, or a referral to another agency or service. I think it can be, just going on this point about empowering people, very empowering and important to actually talk a child or a rangatahi through, hey, we're going to need to share your personal information. Here's why. Hey, have you got any concerns about that? It also gives them a chance to correct information, because we don't always record it right. And so giving them that opportunity should hopefully build their confidence and understanding of what personal information is, and hopefully that sets them up as well to have that knowledge to carry through their life as well.
I couldn't agree more. And in fact, one of the changes that we had that came in as part of the Privacy Act 2020 was I'd describe it more as a strengthening of information principle 4, which is about the way in which you collect information and ensuring that it's fair and not unreasonably intrusive, but also was included in here making sure that the manner of collection with a child is, you're going out of your way to make sure that it's fair. And that means explaining it in a way that a child really understands, talking them through why this matters to them and what they can do and what their rights are. So that's a really critical part of working with children, but working with anyone, but children in particular. And as you say, if we can, if we at OPC can do anything to help social service providers understand that aspect of the Privacy Act and the rights that the child has in terms of access to their information, really being able to ask why this is happening. We're there for you. So I do think that's critically important, which takes us to the another issue that you raised, which was about access to personal information. one of the things that people often don't realise is that access is an entitlement under the Privacy Act, that New Zealanders are entitled to ask for access to their information and to have it corrected if it's inaccurate. And it's probably the most prescriptive part of our Act, actually.
Exactly.
That's something that if it basically both means that the kaimahi you're talking about in terms of from a social services provider perspective need to be ready to provide access to that information, but also potentially to work with individuals who want to get access to other information about themselves that is potentially held by government departments. If individuals do ask for access and they aren't able to receive it or aren't sure that what they've received is accurate, then they can, of course, come to us.
Exactly. I think that's a really important point, the point around access to personal information, super important for all of us working in social service organisations and the wider social sector to remember that. And I think it really, what I think is important to emphasise there, Liz, is around the importance of having those good processes set up in the first place in every organisation, no matter how large or small it might be, so that when someone inevitably at some point does come to your organisation and say, hey, I received a service from you, or you worked with me in 2013. I'd now like to access my personal information, or requesting a copy of my case file or notes on me. Being well set up to be able to respond in a timely manner to that request is very, very important. And it shouldn't be seen as something that's an annoyance or a frustration. This should be part and parcel of how we do our mahi in social services, because it goes back to what I said earlier, around this personal information is a part of that person. And we also need to recognise, because of the nature of some of the mahi that we're doing in social services, especially with children and tamariki, that sometimes what is written or recorded in a case note or a case file may be the only place for some children and tamariki where their story of their identity or some of their childhood experiences is recorded. And we know that because of the nature of the work that we do, often trauma is part and parcel of the experience of people who we're walking alongside. And so for someone maybe years later to access that personal information and to learn something of their history as it was recorded at that time can be very, very crucial for them. So I think it really, as well as being able to access that, it also highlights for me the importance of the importance and the responsibility that social services workers, such as social workers perhaps, who are creating those case notes, have a real obligation and a responsibility and a duty to take a lot of care with how personal information is recorded. Because indeed, as we've seen through recent work such as the Royal Commission of Inquiry into Abuse in State Care, sometimes survivors of abuse will want to access their information. And it may be the first time that they're actually seeing some of that stuff written down. And so the care that a worker, kaimahi, takes in recording that, very, very important, and actually a position of quite considerable power to be in that position of recording someone else's personal information and their history and their story, their whakapapa maybe.
I agree. Just by the way, I noticed that we do have a question that related to something we were talking about before, which is about informing children. And the question was, is there an age from which you absolutely need to do this, or is it related to their level of understanding? And I mean, obviously this will be a judgment call. Often you will have caregivers involved, but What's your view about age limits?
Yeah, look, I think we can't, what I would say to whoever's asked this part is that, we can't start early enough, really. And so we should always give children and young people that opportunity to, hear that information. Obviously, it needs to be shared with them in a way that they are going to be able to understand it. And there are some practical limitations, I think, around, really young children in particular, where that does pose some challenges. But I think back to the UN Convention on the Rights of the Child, which gives us a framework for how to approach these issues of age and stage of children. And it talks about, ensuring that children when it comes to their right to participation, for example, under Article 12, that they are able to participate in line with their evolving capacities. And it's not always hard and fast in terms of, for some 7-year-olds, they'll be able to have a really strong comprehension of some of this stuff, but some others might not be able to. So it is, as you say, Liz, I think it's a judgment call, navigating that with the particular child or tamariki that you're working with, and making the appropriate decision to help them to understand if that's the right thing to do in that time and that moment, ensuring that you're communicating with them in a way that will help to build their understanding. And that's breaking things down, even to helping them first to understand what is their information, and then what is the decision that's going to be made, the reasons why for sharing that information, and how it might be used. So various pieces of the puzzle, and I think professionals need to basically use their good judgment to decide.
And just going back to the point that we were discussing about access, we've actually got a special purpose seminar later in the week, which is called How to IPP6. IPP6 is the access principle, which is really about how to handle a request for access to information. So please tune into that seminar. Our complaints team are going to be taking that particular seminar, and they're really conscious of the fact that sometimes there's other people's information mixed up with the information that about a particular individual, and you have to work those things through.
That's a big one, I
think.
Which
is a really big one,
exactly.
and comes to the issue of the fact that we're talking about people's lives, and people's lives interact with other people's lives, and how do we handle this?
Yeah, and I can speak from first-hand experience, I guess, of working in privacy roles within social sector organisations, of having to sit with case files and navigate, whether certain information should be released to a requester or not. It's not easy, and I think for anyone out there who's navigating this, I would just say, make sure that you've got a good team of people around you. I'm always a big one in this space in general, but in this space in particular, ask others for help, and ensure that you are sounding boarding it with another person to get their perspective on it, because it, as you say, Liz, often in these case files, personal information is entangled with others because of the reality of the nature of family and whānau relationships. And so needing to take a lot of care to actually go through that process and then have it properly checked to make sure that the information that you are ultimately releasing to a requester is the right information that they should be receiving is very important. And I think sometimes as well, if it's appropriate, rather than presuming that that person might know that information, if it's open to you, maybe checking with the other person who's involved to say, hey, would this person have known this information about you or not, for example, can be another way to approach it.
And we're really conscious that in the case of, say for example, let's think about oranga tamariki, that we're often talking about whakapapa-based care. And so we're really conscious here at the Office of the Privacy Commissioner that the Privacy Act tends to focus on individual privacy. But from a Te Ao Māori perspective, of course, there are aspects of collective privacy. And so that's something that we're currently working through say, Waranga Tamariki with Taonga Māori, to think about how do you take a tikanga-based approach to privacy? How do you think about privacy from a collective perspective? And how do you work through those issues? Because ultimately they're critically important if we are actually going to really focus on children.
Yes.
Now, I've got a number of questions coming through, and I'm conscious that it's just after past. So one of those goes to the issue of security. And this particular question says, if you were a smaller organisation or even a marae that doesn't have access to solid security systems compared to those larger organisations or government agencies, what tools or apps would we suggest that you use to secure your private information? So what I'd start off by saying is, you will have seen in the media recently, we've been talking an awful lot about cybersecurity recently. The fact of the matter is that there are people out there today who make their livings out of hacking people. They're cyber criminals, and they're good at what they do. So all organisations, regardless of whether you're a very small provider or whether you're a very large organisation, have to assume that at some point, you may well have a breach. But when we look at organisations, we say, well, you should prepare as well as you possibly can, given the size of organisation you are. So we're looking for people to take what is a reasonable step for you, and what is a reasonable step for you will be different if you're a very small organisation from being a very large organisation. But it's interesting that people often think about tools and apps and other things, and they're important, and I'll get to those. But one of the very first and most important things you can do in order to protect information is to only collect what you absolutely need. Because if you don't need it, then you don't need to protect it. So first thing I'd say to anybody out there is think about, what do I absolutely need to collect from this person in order to be able to provide them with services, and only collect that. And then, think about how long you need to keep that information for, and where you'd store it. But it's particularly important to really understand what it is you're holding on to. Understand the sensitivity of it. Some of the information you collect will be really sensitive. Others may have varying degrees of sensitivity. And the next thing I'd say is make sure that if you are holding on to information, that only the people who need to see the information can access it. So within your organisation, think about who has access privileges to the information, and depending on what you're talking about, that could be within a information system, or it could be just who has access to the filing cabinet.
Exactly. Yes.
So and knowing who has those things, and then I think it's actually about if you do, for example, have you do have a small IT system with, maybe you're using some form of, Microsoft Outlook, or you're using an email system. Make sure that you're appropriately password protected, that you've got, 2 forms of authentication, those sort of basic things. If you're very small, if you're larger, then you'll have access to ICT security people to help you with that. But the basic things to make sure that information is kept safe. If you do have an IT system, access to a cybersecurity professional from time to time just to test it for you is also a good way of doing things. So those are some of the basics, but I can't stress enough that your starting point is always, do I really need this? Because once you have it, you are the trustee of that information. Yes. You are the kaitiaki of it, and you need to look after it.
I think that's such an important point to emphasize to everyone out there that's listening and watching today, because as you say, Liz, once we actually collect that information as organisations, whether or not we like it, we do have obligations and responsibilities then under privacy law and under other legislation that we need to comply with. So, and I think I'd just add, in addition to what you've already shared, Liz, I'd say that no matter how, resource stretched or the size of your organisation, what it might be, I do think that having in place a sound privacy policy can be a really important thing that that all our organisations should have, because that should then govern and provide guidance around things like, as you say, it's down to the paper copies and then also the online as well. And it should give guidance around even quite simple things like, where we're securing information, how it's locked up, that care is taken around, not leaving things on the photocopier or leaving that USB drive behind, and then something else that this issue around cybersecurity is a really important one with our social service providers, and something that we are increasing our focus on at SSPA, because it is important for everyone. And I think the CERT organisation, CERT NZ, has some really helpful tips around things like what Liz mentioned relating to two-factor authentication, how to make strong passwords, that sort of thing. So quite practical help.
Yeah, those sorts of practical tips I think are really important. And the steps that I took you through in terms of only collecting what you need, etc., are the key steps that you'd have in a privacy policy. And the other thing that you can have is a privacy statement, which is actually you just in very clear language explaining to people why you're doing this in the first place, how you're going to collect it, what it's going to be used for, those key things that we ran through before. I do think too that the other thing to bear in mind, and I'm conscious of the fact that there was a survey done by Grant Thornton around not-for-profit providers last year, which indicated that only around 50% of providers have a privacy officer. Now, first thing I'd say is it's a legal requirement, yes, but more importantly, in some ways, your privacy officer is, the person who skills themselves up on privacy and who is a key conduit between us at the OPC and you, who can work with us if you ever find yourselves in a situation where you do have a privacy breach. That's the person who can, we can walk alongside and help as you work your way through this sort of thing. So so it's important for you to have a privacy officer. If you're very small, it can be one of your existing kaimāori. And we've got great resources on our website to help you learn about the Privacy Act. But more importantly, as I say, that's the person who we can have conversations with if you ever need to.
And I think the point around that doesn't need to be someone that you're just employing to solely be the privacy officer. In most social service organisations, it's going to be a small part of the role that someone is already doing, but really important that you do have that person in place, because in an instance where something unfortunately does go wrong, let's hope it doesn't, but in the case that it does, having that person that other staff members can go to for information, but also who has that relationship with the Office of the Privacy Commissioner is really, really useful. And I think as well as some of the training and resources that your organisation has, even on your website, so accessible and helpful, and relatively easy for someone to step themselves through some of that training to be a privacy officer, to get clued up on this, and then to be able to share that information information. And something that I encourage, you know, people in these kinds of roles or with this privacy officer responsibility to do, as well as to connect with your fellow organisations out there. You know, you're all working across and collaborating with different social service organisations. Find out who your colleagues are in other organisations who are also privacy officers. Might be a chance to locally, you know, build a bit of a network of privacy officers so that you can be sharing that taonga with one another, or checking in with each other. Oh, I've got this issue that we're navigating, you know. That can be quite supportive in a way to, you know, build each other's capability and competency as well.
The other thing is that if it would help, we would be very happy to, you know, if you actually built a network and you had wanted to have a sort of I don't know, a round table
Forum,
a forum of social services providers, privacy officers that we could just sit down and have a chat with and we could work through issues. We'd be very happy to do that.
Great. Well, if there's appetite for that, then let's
if
make that happen.
If there is appetite for it. I've got another question, which is here, which is that the Public Records Act is used to override the Privacy Act, which I thought I might just deal with that one. The Public Records Act, so the Privacy Act does have a number of acts that basically do work with it and sometimes override it. The Public Records Act does require the collection and retention of certain public records. And the way that we tend to think about it here is that the Privacy Act and the Public Records Act work together. So we would really strongly suggest that when you collect that information, you know, we were talking before about the fact that you collect only what you need. As you're collecting it, make yourself something that is, you know, called a retention schedule, where you're essentially saying, here's what I'm collecting, and here is how long, this is what type of information it is, and this is how long I'm going to keep it for, and then review it. That's what the Public Records Act requires you to do. And then you can, if you're at the point where you're wondering whether actually this is information that should be archived from the point of view of the Public Records Act, you can always check in with Archives New Zealand. And if it is the sort of information, like, for example, the information that is currently being accessed to support the Royal Commission, that can actually be given to archives to hold on to. So, so it becomes a matter of public record, but it's held on to by archives. And that then means that the social services provider doesn't have to hold on to it themselves because it's being looked after.
Yes. Yeah. And I think that's a helpful way to look at it, what you said about, you know, that these different pieces of privacy legislation work together and work in tandem with one another. And so often it's not necessarily as clean cut as sort of one piece of legislation overrides another. We always have to look at, I always think the Privacy Act is always underlying everything in this space. Absolutely. You know, even in the Oranga Tamariki Act, you know, with the what we discussed earlier, Section 66 and associated subsections. Whilst you might be able to apply those, still underpinning it all, of course, is the Privacy Act and the various privacy principles set out in that Act.
That's right. And I think that goes to a question, another question I've got here, which was, you know, what are some of the other exceptions or grounds for exception to a child information in terms of child information privacy, by which I'm assuming people are meaning occasions where one can share. And I mean, as we've said, you know, there's protection and safety of the child, but it also goes back to the reason you collected the information in the first place. So sometimes there will be important reasons for you sharing that information with another agency, for example, another government agency. And so that's, again, that's entirely allowable as long as it's connected to the original purpose for collection.
Yes.
So again, really good reasons for being very clear upfront why you're collecting and who you're going to share it with.
Absolutely, yes. And to just add to that, there will be instances sometimes where for the purpose of ensuring that a child or a family member is able to access the services that they might need to support their well-being and their oranga, that information needs to be shared. So that's another instance, for example, in addition to the immediate safety concerns, for example, of a child, to enable services to be provided in a way that supports that child's well-being, might need to share information as well. And then I guess one other area that I think of as well is the Family Violence Act, so Family Violence Act 2018, that also makes clear that information can be shared in order to prevent family violence, for example, so or respond to family violence.
But I would say to social services providers and to people out there, when information is requested of you, always go back to that core principle, which is, why did I collect this information? Yes. What is the purpose that I collected it for? And is this agency or what have you that is asking me for this information, do they actually have the ability to do so? And really double checking that.
I think we can't emphasize that enough for everyone out there. I think the need for that very careful assessment to look at, okay, first of all, what was the purpose that we collected this information for? Are we actually able to share it? And then to exercise that good judgment around, whether or not sharing it in this instance is the right thing to do, and for what purpose. We need to look at, does this information need to be shared to get the job done, for example, of keeping a child safe or well. But also, I think it goes back to something that we discussed a bit earlier, Liz, only sharing the information that's necessary to do that job right. And so there I'm talking about really important that we don't just blanket, okay, here's the whole file. Just looking at what is the specific information about that child or about their situation or about that family or whānau that needs to be shared in this instance to keep them safe. Yeah, it oftentimes will not be everything, that's for sure.
Absolutely. I've got another question, which is a sort of like a pretty much up at the moment type question, which is about TikTok and Snapchat and the peer pressure that rangatahi often come under to share their location with each other, and the end part of this question, which is sort of like a statement in some ways, is one that we hear a lot, which is, hasn't the horse bolted? And I think in privacy fields we've been hearing, hasn't the horse bolted, every time there's a change in technology. The cat's out of the bag, we can't really do anything much about it now. Our advice would be, there's always the opportunity to talk to rangatahi, and to think ourselves about what we share online. It's never more important, and now with the advent of AI, types of technology which are capable of really searching more and more of our social media presence and what's on the internet, it's even more important to have that conversation with rangatahi about, how much do you really want about yourself out there?
Absolutely.
And I guess what we've said about privacy is that fundamentally it's about allowing people to develop their identity and with that safety to be able to grow and develop. So our advice would very much be to continue to have that conversation with young people about what actually they are doing with their online presence.
Agree. It has to be an ongoing conversation, and I think it is an ongoing conversation, I think, amongst young people in rangatahi themselves, but also for those of us who have the privilege of working alongside children in rangatahi. I think we have a responsibility because of the age that we live in, this data age that we're in, and as you say, with continued evolutions in technology and rapid advancements around, you know, things like even voice recognition, facial recognition, we need to recognise that even a short snippet of a video or a little photo that, you know, we might not think anything of, but it's there for, it's very hard to get stuff taken down off the internet, let's face it. So ensuring that young people are aware of this is so essential. I think, you know, our young people in rangatahi in Aotearoa, New Zealand, they are pretty switched on, and a lot of them are very switched on to this already, you know, and are taking active steps to protect their own data and their online identity and presence, because of, you know, some of the things that we know can go wrong. But I very much believe that as social services kaimahi, because we're working with rangatahi, we have a responsibility to help them to build their understanding and knowledge about this. And also, you know, I think about some of the rangatahi who I've worked with in the oranga tamariki context. Even more important sometimes for them, given some of the safety concerns that they might be experiencing, that even if we're at an event with them, for example, we are not taking photos that are going to be shared. Sure, take photos to record those moments for them and ensure that they are in their puka puka or, you know, shared back to them digitally. But we don't share those because that's part of our responsibility to keep them safe too.
I agree entirely. I'm really conscious we've only got 5 minutes left. One thing I did want to say on the subject of children's privacy though is that we've just kicked off a major project here at OPC focusing on children and young people's online privacy, digital privacy. We're going to be wanting to come out and have a chat to you, Claire, and all of the people who are listening here around this piece of work. It's critically important. We want to understand what we can do to make the online world a bit safer for young people. People should have as many rights online as they have in the physical world. So I'm going to wrap up now. Thank you so much to everybody who's participated. Thank you to Claire. We've got lots of questions coming in here. If we haven't got to them here today, we will come back to you in writing. And we'll also look to put things up on our website. So can I say thank you so much to all our listeners. Thank you, Claire. If anyone does have any further questions, don't hesitate to get in contact. But from me and from Claire, ka kite, take care and happy Privacy Week. Yeah, we're out. We can probably take questions.